Only on the next day, his mother could approach the police station and take him to a doctor, as the police did not do so. When the boy was taken into custody, his mother was not even notified of the same. He died out of injuries, eventually in the hospital. And recently, on July 10th, 2020, gangster accused Vikas Dubey, who was arrested in Ujjain, Madhya Pradesh, was killed by UP police near to Kanpur by firing. Vikas Dubey was arrested from a temple in Ujjain, Madhya Pradesh, and as per the report, he never resisted the arrest. It was practically a surrender to the police out of fear of life in encounter killing, as 5 of his own associates, co-accused, were killed by the police in separate encounters. Dubey was handed over to UP's Special Task Force after his dramatic arrest in Ujjain and was being escorted back to Kanpur by UP police team. It is now clear whether he was produced before a magistrate in Madhya Pradesh itself. In law, there was no inhibition in producing the accused when he was arrested outside the concerned state to produce him before a magistrate in that state, that is Madhya Pradesh. Anyhow, as per media reports and visuals, the narrative and explanation given by the UP police are shrouded in mystery, and its veracity is clouded with serious doubts. Killing of 8 police personnel of the team of police for arrest of Dubey and his men 7 days before this incident is a condemnable crime. But this itself reveals the state of law and order situation and police criminal nexus in UP. It was on record by the UP police itself that the said killings of 8 policemen of the police party for search and arrest happened as 2 police cops tipped off to Dubey regarding police action for search and arrest. That shows the nexus between criminals and the police. It is very pertinent to note that nearly half of 1,782 encounter death complaints registered with NHRC between the year 2000 and 2017 were from UP alone. Similarly, 38,000 out of 78,000 human rights violations brought before NHRC in the year 2017-2018 were from UP. The credibility of the justice delivery system itself is in question. It is high time that judiciary intervene for restoration of rule of law and force the police to comply the legal mandates in letter and spirit. It is very much necessary to break criminal police politician bureaucrat nexus and extract judicial punishment with the police by way of fake encounter killings or otherwise. Accountability of the police in such matters is big zero in UP. A restoration of accountability by fixing the liability is the need of the hour. Now, fortunately, the Honorable Supreme Court of India has intervened in the matter, not on suo motu, but on petition filed by an advocate. In fact, he filed the petition even before the encounter killing in which Dubey was killed. The petition was with a prayer that his life should be protected. He might be met with the same incident, same fate as of his co-accused. But at that time, Supreme Court could not or did not take it up. Subsequently, after the encounter killing, Supreme Court took the matter up, and now the incident is ordered to be inquired into by a special team of a former judge of the Supreme Court and a high-ranking retired police officer. Dear friends, the track records of various states in the matter of custodial death or encounter killing would reveal that this is not a simple aberration of the police, not a mere mischief by any trigger-happy police personnel. It is something beyond. In the year 1999, the Supreme Court had to consider matter of 99 encountered incidents causing 135 deaths during the period of 1995-97 in Maharashtra. In yet another matter of reported as Henry Prakash Kadam, the Supreme Court was dealing with encounter killing of a person by police as a counter killing for another criminal. And in 2016, Supreme Court had to deal with the issue of filing FIR, compensation to death victims, and for various other reliefs in the matter of encounter killing by Manipur police and CRPF. All these incidents, all these recurring incidents of cold-blooded murder are being reported despite the mandatory directions and guidelines issued by the Honorable Supreme Court in the matter of arrest, police custody, judicial custody, prison detention, and encounter killings. It is in the year 1997, in the celebrated case of D.K. Basu, that Supreme Court issued mandatory directions for protecting human rights and to prevent custodial violence, torture in the matter of arrest, police custody, etc. Altogether, 11 directions were issued as there were no sufficient protective or preventive mechanism in the statutes. And these guidelines, the directions, are practically incorporated subsequently in the statute book in the CRPC regarding arrest and custody by amending CRPC. One of the important guidelines given by the Supreme Court to be compliant mandatorily is arrest should be notified to the relative of the accused, the arrestee, and various other directions to torture, proper inquiry, etc. I am not giving all the directions. As practicing lawyers, you are well aware of it. But a funny incident happened with respect to judgment in DK Basu is worth mentioning. A superior police officer issued communication to police stations under his jurisdiction to report about complaints of guidelines in DK Basu case. A reply from a particular police station, and that too from Kerala, was that there was nobody by name DK Basu in custody in that police station. That shows the awareness of the station house officer of that police station. And that too, it happened in Kerala. Of course, it is far back. Still, even those times, Kerala was considered as a modern state in certain respect in the matter of police administration. Anyway, in the year 2014, in the PUCL case, People's Union for Civil Liberties is an NGO. They took up the matter regarding encounter killings. Series of encounter killings happened in Maharashtra. Ultimately, in the case report in 2014, 10 SCC 635, Supreme Court scrutinized, considered all previous decisions and guidelines with respect to police custody, custodial violence, and encounter killings, and gave a revised 16 directions by way of guidelines. It is based on these guidelines that a special provision was incorporated in the CRPC, that is 176(1) capital A, with respect to mandatory inquiry by a magistrate in the case of unnatural death in police custody. This inquiry is not the inquiry usually conducted under the statute or investigation by the police. It should be by magistrate. Very serious directions are issued regarding inquiry and investigation in the matter of encounter killings, custodial violence. In case in the inquiry, we found that police officer involved in the incident had committed crime, and the projection of the incident as encounter killing was totally a false story, and it was a fake encounter, necessarily concerned police officer should be prosecuted for offense under section 302 for murder. Not only that, in such situation, in a given case, if you are able to establish that that incident was a cold-blooded murder and not an encounter killing, to protect police personnel from attack, Definitely, the victim's kith and kin is entitled for compensation, compensation from the state itself. And for that, you need not resort to civil remedy before a civil court by way of suit at all. You can straight away move repetition under Article 226 or 32, claiming compensation as public law remedy. So, custodial violence, whether torture, rape, death in police custody, whether lockup or judicial custody, and or fake encounter killings, all these sort of violence envisages Article 21 of the Constitution of India, as well as basic human rights, and strike a blow at rule of law. It is blot on rule of law. Torture involves not only physical suffering, but also mental agony. It is naked violation of human dignity and destructive of human personality. Article 21 is for protection of life and personal liberty. No person shall be deprived of his life or personal liberty except according to a procedure established by law. That procedure or law should be just, reasonable, and rational. There is no law permitting the police to subject the accused or person in custody to torture in any form. Article 22 is against illegal arrest and detention. Article 20 mandates that no person accused of any offense shall be compelled to be a witness against himself. So you cannot torture an accused to extract any confession. Torture is one of the horrible forms of violation of human rights. The Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment of Punishment, 1984, of the United Nations General Assembly defines torture. In the municipal laws, in the statutes in India, there is no definition for torture. And for that matter, there is no specific law in India to prevent torture. But Article 21 of UNCAT, that is Convention Against Torture, says that definition. I may read out for you because that is necessary. For the purpose of this convention, the torture means any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him or a third person information or a confession, punishing him for an act he or third person has committed or is suspected of having committed, or intimidating or coercing him or a third person for any reason based on any discrimination of any kind, when such pain or suffering is inflicted by or at the instigation of or with the consent or actions of the public officials or other persons in an official capacity. So this is the widest definition of torture, with necessary practical certitude. It is not vague at all. But it does not include pain or suffering arising only from inherent in or incidental to lawful sanctions. So, dear friends, torture in any form, whether it's custodial violence, police beating, or fake encounter killings, they are against UN Declaration of Human Rights binding on India. The UNCAT Convention Against Torture, though was signed by India, is not yet ratified by India. That makes a lot of difference that I will relate to later. UN Declaration of Human Rights is binding on India. Not only that, our constitutional provisions, as just I referred to, that is 20, 21, and 22, are broadly in consonance with the UN Declaration of Human Rights. Moreover, India is party to International Covenant on Civil and Political Rights, International Covenant on Economic and Social and Cultural Rights, and India has signed United Nations Convention Against Torture and Other Cruel, Inhuman, Degrading Treatment or Punishment, 1984. Though India signed it in 1997, not ratified till now. Over and above all these things, to make it precise, we have got our Human Rights Act 1994 for human rights regime with the National Human Rights Commission and state level human rights commissions. Unfortunately, as observed by the Supreme Court, NHRC is made a teethless tiger by the executive government by commissions or omissions, by without providing sufficient staff, sufficient budgetary allotment, and strong investigation team on its own. But one thing we have to mention about our Evidence Act. One of the best contributions made by the British while drafting Evidence Act of India is that to positively prescribe that confession made to police officer is not evidence admissible. Kindly refer to section 24, 25, and 26 of Evidence Act. Confession made by anybody in police custody also is not admissible. The exception is that in such a case, if there is any confession to be admitted as evidence, to be proved, it should be before a magistrate. Let us think of a situation in the absence of section 24, 25, and 26. Of course, there is 27, section 27, there is an exception. You all knew that regarding recovery, police recovery under section 27. That is the exception, and only the recovery part is admissible evidence. Otherwise, the police would have and could have tortured innocent persons to make confession against, to extract confession, false confessions, confession against truth, admitting that the crime was committed by the person out of sheer violence and out of fear of life. So the duty of the police is to investigate, interrogate on scientific principles. Third-degree methods are totally impermissible. It is not the duty of the police to kill the accused merely because he is a dreaded criminal. Supreme Court of India repeatedly admonished trigger-happy police personnel who liquidate criminals and project the incident as an encounter. And it was judicially observed as such actions amount to state-sponsored terrorism, which cannot be tolerated, encouraged, or accepted. Krishna said, custodial death is one of the worst crimes in the civilized society. It is highly despicable and worse than terrorism, as it is state-sponsored or sanctioned criminal action, inhuman action. Killing of accused by the police without bringing them for trial before the court of law is not only violation of human rights and an offense under Section 302 IPC for murder, but it also suppresses and obliterates evidence of criminal, politician, and police nexus, as in the case of Dubey, Vikas Dubey. Only because of police criminal nexus, Dubey was tipped off the police action for search and arrest. And that itself is the cause for loss of life of 8 police officers in the police party for arresting that Dubey. So all these facts narrated hereto before would only show that the torture in any form by the police as custodial violence or encounter killings is not a mere aberration at the hands of certain insensitive police personnel. It is something beyond that. It is clearly state-sponsored and state-sanctioned terrorist act to overreach the basic tenets of our constitution, human rights jurisprudence, and our composite culture, civilization, respecting dignity of human persons, and of course, the civilization, culture, and our mode of living of non-violence. Dear friends, this is the reason why I am not approaching this subject only from a juridical, statute-based approach. More than juridical and statute-based approach, we want a political answer for this political issue. It is rather a political issue. You may note that Vikas Dubey incident is 119th encounter killing in UP since March 2017. Within 2 years, 119 encounter killings. As per UP police tweet, it is not any allegation, it is police own statement by way of tweet that during the last 2 years, UP police involved in 5,178 encounters. 103 criminals are killed and 1,859 injured and 17,745 surrendered. This is police version. And most shocking statement comes from the topmost political executive, that the Chief Minister of UP. Chief Minister Yogi Adityanath, after taking charge as Chief Minister, has reportedly stated, very, very shocking, if you commit crime, you will be knocked off. This is the statement reportedly given by Chief Minister of UP. If you commit crime, you will be knocked off. Means if you commit crime, you will be killed. Then, taking the cue from that statement by the Chief Minister, DGP of UP states further, the message from the top is that no criminal is to be spared. So, dear friends, that is why I've been harping on the point that this sort of police violence, custodial death, or encounter killings, they are not simple aberrations by criminal-minded police persons at all. It is clearly state-sponsored terrorist actions. And I can understand that this sort of policy encouraged and declared by the political executive, if there is semblance of law and order, if there is any reduction in number of deaths, dacoity, robbery, or any other sorts of organized violence by gangsters or otherwise, we can understand that despite all our objections regarding this sort of encounter killings, we can understand, not to accept, but still for information, there is no reduction of any such criminal offenses in UP, and this out of organized criminal offenses. It is on the rise, only on the rise. So it could not contain Gunda Raj in UP or any other part of the country. So this definitely takes us to another point, how it tells upon our democracy or our concept of democracy. A society which does not believe in tolerance, secularism, equality, and human rights cannot be democratic. When the political philosophy and concept of democracy of the government in office, the political party in office, is intrinsically in conflict with our constitution, our constitutional principle, conflict with the political philosophy, our constitution, the concept of liberty and freedom in our constitution, then the issue becomes more political than jural. For them, the violence is necessary to disseminate a chilling effect to the citizenry, and that is very calculated. For what purpose? There should be a chilling effect. Who express dissent? So they want to oppress dissent and to overreach the constitution. This is one of the explanations for indiscriminate violence against students participated in anti-CAA protests. You please observe that. Students are targeted. Research scholars, MPhil students who are involved in social activism, all sort of activism committed to the society are selectively targeted. Likewise, minorities, members of the minority community are also selectively targeted. So this makes this issue little bit more complicated. See, they want to develop or manufacture consent for torture, custodial violence, deaths and encounter killings in the society. And for that matter only, they are whipping up primordial, primitive urge of the mass for teeth to teeth and eye to eye. They want to manufacture consent for a benign dictator. Yes, army, military is better than this democratic governments. All these political parties are anti-social elements. They are doing disservice to society. See, our nation is protected, saved by military persons, army people. So they are the heroes. So they are manufacturing consent for military rule, depicting military as liberated and protected the society. For that, they are whipping up jingoistic nationalism. They are creating enemies. They are creating false enemies. Moreover, for this purpose, the dissent is given a grand narrative of treason or sedition. Every dissent, even by an individual unorganized person, not with support of any organization or association, even a dissenting opinion about policy of the government by an individual person who is not associated with any organization, the narrative given by the government or the political party in office is narrative of treason and sedition. Even criticism of prime minister or any of the ministers is depicted as sedition. So the idea behind this sort of encouraging violence is to facilitate undemocratic fascist ideology in the society. Of course, fascist ideology is available in society, but they want to promote that ideology. They want to make that ideology as a dominant ideology in the society. They want to make that ideology dominant in the society to manufacture consent by the majority of the people for this ideology. There is yet another aspect of this. For facilitating this broad manufacturing consent, they are doing disservice to judiciary as well. They blame judiciary for all the delay in justice delivery, but the executive is responsible for the major part of this malady. They are not prepared to allot sufficient budgetary allocation for the judiciary to set up appropriate number of courts, to develop infrastructure, to modernize the judiciary. So this aspect has got bearing on speedy justice, speedy delivery of justice. But they are not prepared. The budgetary allotment for judiciary is 0.08, less than 1%. Our population is 1.31 crores, and our ratio, judges ratio with the population, 17 or 18 for 10 million. 10 lakhs, 1 million. So this is the abysmally small budgetary allotment, namesake allotment by the executive for judiciary. Then they blame the judiciary for delaying justice delivery, arrears of criminal cases, arrears of other cases, and all that. Not that I am whitewashing the judiciary. Judiciary has got its own contribution in this malady, but that's a different aspect. The majority or the major portion of the blame should go to the executive for not providing sufficient infrastructure to the judiciary. They are doing it deliberately. They want to make it appear before the masses that no, you won't get justice from the judiciary. So the police, we the executive, we are doing justice. That person has committed rape of a lady. So the other day, I shot him and killed. So that is the justice delivery. And the mass, of course, in the mass, we are whipping up the primitive ego or thirst for eyes and teeth for teeth. And there is yet another point to be touched upon in this matter. Of course, we know that in majority of organized crimes, accused are acquitted. What are the reasons? Reasons are plenty. One of the reasons is, an important aspect is, there is no effective witness protection regime in India. There is no effective witness protection regime, and there is no witness protection statute also. So, especially in organized crimes, if witnesses are not protected, definitely they become hostile witnesses. So, all these things are to be taken care of by the executive, but they are not doing. They are not sensitizing the police force. They are not sensitizing the armed force regarding our concept of human rights, torture, and rule of law. They are promoting revenge killing. They are promoting contract killing. There are police officers resorting to revenge killing on the ground that one or other colleague police officer was killed by an accused. So this police officer, as part of his revenge, resort to killing of the accused or another accused as revenge killing. And there is most cruel aspect of contract killing. There are incidents which reach up to the Supreme Court where police officers resorted to encounter killing, fake encounter killing, as contract killing for another dacoit or another criminal. There is no question of revenge either. There is no question of any political motive from the executive. So these sort of things are either cause or effect of this encounter killings. And ultimately, the political executive even fixing up innocent persons, political activists, human rights activists, and resort to fake encounter killing. A sort of passing off. When you are whipping up jingoish nationalism, when we are whipping up primitive ego for teeth and eyes for eyes, necessarily you can fix up innocent persons and resort to fake encounter killings, and thereby you can annihilate dissenting persons in the name of sedition, treason, anti-national activities. So all these happen when the political philosophy of the political executive in office is in conflict with the political philosophy of our constitution. That is why the torture, custodial death, and encounter killings are becoming a sorry. So the point I referred to is, in this situation, these encounter killings becoming a political thing, not a simple aberration of the police, one or other insensitive or criminal-minded police. But see the other side of the coin. Take an example of Kerala, LDF government. Whenever the political philosophy of the government in office is in harmony with the constitutional principles of liberty, freedom, human rights, right to life, and our views against torture, custodial death, encounter killings by the police, etc., based on this constitutional principles, we can correct the police force. Whenever such incidents happen in Kerala, the government took the stand that accused police officer found guilty not before trial, even before trial, if there is substantial material to prosecute that person, that accused police officer is prosecuted, brought before law. So there is no difficulty in understanding that situation. If the political executive in office, the government in office is not supporting, encouraging, or accepting this sort of police violence, torture, custodial death, or encounter killings, necessarily we can correct the police. Then that is only aberration by certain individuals in the police or certain groups in the police due to their insensitiveness or criminal mind and everything. So that can be corrected. That is why I referred to before, I stated before, Kerala cannot be bracketed along with other states in the matter of encounter killings, custodial violence, etc. If the government stands for human rights and against torture, we can correct the police force and we can make a positive attempt in that regard. But your political philosophy is in conflict with our constitution. You can't correct it. We can't correct it through any judicial remedy, through courts of law at all. So, dear friends, as I mentioned before, India is signatory to the United Nations Convention Against Torture and other human or degrading treatment since 1997. But it has not ratified that UNCAT till today. It has not ratified its optional protocol as well. Though in 2010, a bill against torture as prevention of torture bill was presented to Lok Sabha, it went to lapse. No, it went to select committee first. Subsequently, it lapsed. Again, in 2017, the Law Commission in its report proposed new anti-torture law as Prevention of Torture Bill 2017, but nothing happened thereafter. So even after 33 years of passing the resolution and now India has not ratified that convention resolution, though it signed the resolution. Now 140 nations of the world have already ratified the convention and its optional protocol. The difficulty is that if you are not ratifying the optional protocol or the convention itself, you are only signing that document, the international regime against torture cannot have an access to a party nation. Only after ratification of the convention document and ratification of subsequent optional protocol, you can implement the international regime against torture. So that is the important aspect. As India has not so far ratified the Convention Against Torture or the optional protocol, the national visiting bodies can't visit the concerned nation and scrutinize the alleged incidents. It cannot implement its regime at all. So without ratification, the Convention Against Torture become a teethless paper tiger. As a matter of fact, Supreme Court itself, more than one occasion, highlighted the need for an anti-torture statute. There was an attempt last time when lynching incidents were on the rise, and today's news reports say another person is linked to death for transporting meat on the ground that he was carrying cow meat. So this is the present situation regarding rule of law, custodial death, and encounter killings. What exactly the remedy? You can have legal remedy in theory. You can approach the High Court or Supreme Court by way of habeas corpus. You can approach the court for compensation. You can even approach the court for contempt of court in certain situations. But you can't get a proper remedy proper relief, because it is not a juridical issue ultimately. If the political party in office promotes this sort of situation, and our concept of personal liberty and our emphasis on liberty is changed even in judicial discourses, how can you get remedy? So the remedy is only to develop a strong bond among all the stakeholders. Our vigil and timely response against this sort of incidents, and try to develop a counter ideology in the society against this fascist ideology. Forge unity with all right-thinking democratic people for creating democratic secular idea in the society, countering fascist ideas. Make a broad platform on limited slogans. When you feel that fascism is at the door, take a stand for broad democratic platform against human rights violation and all other forms of state violence or state-sponsored violence. There is no other shortcut. You can't get simple legal remedy without democratic upsurge from the people, without timely response from the informed part of the society, informed section of the society. And this is a situation where silence is crime. So we have to make voice, loud voice, not mere sound, meaningful voice. And that is the only way out from the situation. And I think I can stop now. And if there is any questions regarding clarification, I can try to answer that. So I once again thank you. Thank you all. Hello? Hello?
Yes, we can.
Hello?
Yes.
Yeah.
Hello.
Yeah.
Yes.
Was it audible?
Yes.
Yes,
Yeah,
audible. Oh,
okay.
Yes.
Okay.
Yes.
Very clear, very clear.
Thank you.
Vijayata, please unmute yourself.
Hello.
Unmuted.
Hello.
Hello.
Nijada, please lead. MC. Vijayakumar.
സുരേന്ദ്ര സാറിന്റെ അല്ല
Yes.
സുരേന്ദ്ര സാറിന്റെ ക്ലാസ് കേട്ടപ്പോഴേ വിനോദേ
Okay.
നമ്മൾ അന്ന് ഹൈദരാബാദ് പോയില്ലേ?
Ah.
ഹൈദരാബാദ് പോയ സമയത്ത് എൻകൗണ്ടർ നടന്ന സ്ഥലം ഓർമ്മയുണ്ടോ?
Okay. Okay.
അത് ഓർമ്മ വന്നു. സുരേന്ദ്ര സാർ ഓർമ്മയില്ല?
Vijayakumar, please.
എനിക്ക് ഓർമ്മയുണ്ട്. അവിടെ നമ്മൾ സ്റ്റേറ്റ്മെന്റ് ഒക്കെ ഇറക്കി എനിക്ക് ഓർമ്മയുണ്ട്.
Yes.
അതെ എയർപോർട്ടിൽ നിന്ന് പോകുന്ന വഴിക്ക്.
ഇപ്പൊ കിട്ടി. അതിൽ അഭിപ്രായ പ്രകടനങ്ങൾക്ക് ആളെല്ലാം ഒന്ന് ക്ഷണിക്കറ. പിന്നെ വിനോദ് എല്ലാരെയും ഒന്ന്
First of all,
ക്ഷണിക്കും.
Mr. Vijayakumar, several other persons from other states also participating in the program. So please, first of all, you lead some comments or some opinions.
ആര്?
Mr.
ഞാനാ?
Vijayakumar. Yes.
KK വിജയകുമാറുണ്ടാ?
No, yourself.
KK is not with us today. OG is with us now.
OG is there. OG-യോട് ലീഡ് ചെയ്യാം.
ഉണ്ട്.
OG-യോട് 2 വാക്ക് പറയാൻ പറ.
I think he has gone now. Here.
പോയാ?
ഇല്ല ഉണ്ട്.
ഉണ്ടാ?
Premvakile. Unmute ചെയ്തിട്ടില്ല പ്രേംവക്കീലിനെ.
അൺമ്യൂട്ട് ചെയ്തില്ല. ഉണ്ട് പ്രേമരാജ ഓജി കാണുന്നുണ്ട്.
ഉണ്ട്. പ്രേംവക്കീല് കെ അശോകൻ ഉണ്ട് ട്രിവാൻഡ്രത്തുനിന്ന്. കെ അശോക്. അതുപോലെ അനിൽ ചൗഹാൻ ഉണ്ട് ഡൽഹി.
ഇപ്പൊ ഇല്ല പോയി
അല്ലേ?
ഇപ്പൊ പോയി.
വേണുഗോപാൽ റാവു ഫ്രം തെലങ്കാന അവർക്കുണ്ട്. നൗഷാദ് ഒന്ന് ഡിസ്കഷൻ തുടങ്ങൂ. നൗഷാദ്
ബാബ സാഹിബ് വാവാൽക്കർ.
സാഹബ് അല്ലേ?
അതെ ബാബാ സാഹിബ് വാവൽക്കർ.
See, Vinod.
Yes.
If there is no query, don't worry about it, because that means so. No, I cut short actually because I thought that somebody was telling me that 5:30 is another program and all that. That's why I cut short. Otherwise, I would have covered that torture aspect in little more detail. Yeah, tell me if anything. Otherwise, we can wind it up. What is it?
ഇതില് ഡൗട്ട്സ് ഒന്നും അങ്ങനെ ചോദിക്കാനില്ലല്ലോ.
അതാ പറഞ്ഞത്.
ജൂറിസ്പ്രുഡൻസ് അതിന്റെ അല്ലെ ഒറിജിനൽ തോട്ട്സ് നമ്മളിങ്ങനെ സ്റ്റാറ്റ്യൂട്ട് വെച്ചിട്ട് ചർച്ച ചെയ്യുകയും ഒക്കെ ചെയ്യുന്നത് പോലെ അല്ലല്ലോ ഇത്. ഒരു ഒറിജിനൽ തോട്ട്സ്.
അതല്ല, ഇതില് ഒരു പ്രധാനപ്പെട്ട കാര്യം എനിക്ക് പറയാനുള്ളത് വെച്ചാല് ഇതേട്ടാ, അതായത് ഈ വിറ്റ്നസ് പ്രൊട്ടക്ഷൻ എന്ന് പറയുന്ന സംഗതി അങ്ങനെ ഒരു ഐഡിയോളജിയെ വളർന്നു വന്നിട്ടില്ല. കാരണം എന്താ വെച്ചാല് ഓൾ ദ വിറ്റ്നസ് ആർ ടേൺഡ് ഹോസ്റ്റൈൽ and they are not even making any payment for their service also. So that area has to be discussed in detail, because even a central statute or a state statute is required to protect the witness and to strengthen the legal system. Unfortunately, no such idea is not popular in the whole country.
That is it. That's correct. Most of the cases ingane avasanikkudinte karyam adana. Witnesses are not considered as guests of the court. They are not rather respected for the reason that
By
they
the
are coming
court.
to the court to say fairly, to depose about the truth or real incident. It's not being respected. ആ ഒരു കുഴപ്പമുണ്ട് നമ്മളെ സിസ്റ്റത്തിൽ. അങ്ങനെ അങ്ങ് നമ്മളെ കുറെ കേസ് ചുറ്റിച്ചു പോകുമായിരുന്നു.
There is a proposal for regarding 161 statement.
അത് പക്ഷേ
Now it is
അത് നമ്മളെ ഇയാളുടെ
That is not the answer.
ബസന്തിന്റെ ഡിസിഷനിലൊക്കെ പറഞ്ഞില്ലേ, വൈക്കാണ്ട് ബി നല്ല
yes.
സീനിയർ ഓഫീസർ ആണെങ്കിൽ നമുക്ക് ഇതങ്ങ് സ്വീകരിച്ചൂടെന്ന് ചോദിച്ചിട്ടില്ലേ. അത് ഈ
Yes.
പോലീസ് എങ്ങനെയാണ് ഇത് കൺഫോം ചെയ്യുന്നത് എന്നുള്ളത്.
അതുകൊണ്ടാണ് ഞാൻ പറഞ്ഞത് ബ്രിട്ടീഷുകാരെ ആകെ ഒരു നല്ല കാര്യം അതാണ് 24 25 പോസിറ്റീവ് എഴുതി വെച്ചത്.
അക്സെപ്റ്റബിൾ ആക്കിയില്ല എന്നുള്ളത് ഒരു വലിയ. അത് പക്ഷേ പിന്നീട് വരുന്ന സിസ്റ്റം സ്റ്റാറ്റ്യൂട്ട്സിലെല്ലാം പോലീസ് ഓഫീസർ
ആണെങ്കിൽ പോലും
അല്ല, കാരണം എന്ന് പറഞ്ഞാൽ ഈഗർലി ദേ വാണ്ട് ടു റാദർ റിജക്ട് ഇറ്റ്, ദി സ്പിരിറ്റ് ഓഫ് ദാറ്റ് 24-25 എല്ലാം. അങ്ങനെയാണ് പുതിയ ലോ മേക്കിംഗ് ബോഡിയുടെ തോട്ട്സ് എന്ന് പറയാം. പുതിയ ജുഡീഷ്യൽ ഓഫീസറുടെയും തോട്ട്സ് ആണ്. പഴയ ജൂറിസ്പ്രുഡൻസിന്റെ ഒരു വളരെ സ്വീകാര്യമായ ചില സംഗതികളാണ്. വിനോദ ഡൗട്ട്സ് ഒന്നും ഇല്ലെങ്കിൽ പിന്നെ അത് മുന്നോട്ട്
സംശയം നോക്ക്, കൊറിയൊന്നും ഇല്ലല്ലോ.
അല്ല, ഇതൊരു വേറെ രീതിയിലുള്ള ക്ലാസ് ആണല്ലോ. നമ്മളൊരു നമ്മുടെ സാധാരണ നടക്കുന്ന ഒരു ക്ലാസ് പോലെ അല്ലല്ലോ. എന്താണ് അതിന്റെ ഒരു സംശയം?
വിരുദ്ധാഭിപ്രായം ഉണ്ടാകാനുള്ള സാധ്യതയില്ല. പിന്നെ കോംപ്ലിമെന്റ് ചെയ്യാൻ ആർക്ക് ധൈര്യം ഉണ്ടാവില്ല.
കുറച്ച് കേസ് ലോസ് കൂടി ആവായിരുന്നു. ഈ കസ്റ്റോഡിയൽ ടോർച്ചറിന്റെ ഒക്കെ അങ്ങനെയല്ല പറയാൻ വേണ്ടി പറയല്ല. നമുക്കൊരു ഇനിയൊരു സെഷൻ ഇത് സംബന്ധിച്ച് സംഘടിപ്പിക്കുമ്പോ അതുകൂടി ഒന്ന് നമ്മളിപ്പോ പെട്ടെന്ന് പറയാൻ പറ്റുന്ന സംഗതി അല്ലല്ലോ. ഒരു ചോദ്യത്തിന് ഉത്തരം പോലെ പറയാൻ പറ്റില്ല. പക്ഷെ ഇനി ഇത് സംബന്ധിച്ച് കൂടുതൽ ഡിസ്കഷൻ വരുമ്പോൾ കുറച്ച് കേസ് ലോസ് കൂടി ആ ഉണ്ണികൃഷ്ണൻ വേഴ്സസ് സ്റ്റേറ്റ് ഓഫ് കേരള അതുപോലുള്ള കുറച്ച് ഇതുണ്ടല്ലോ ആ കസ്റ്റോഡിയൽ ടോർച്ചറിന്റെ ആ ഒരു ആസ്പെക്ടിലേക്ക് കുറച്ചുകൂടി റിസർച്ച് ചെയ്യേണ്ടതുണ്ട്. ഞാൻ അങ്ങനെ സ്റ്റഡീഡ് അല്ല.
അല്ല, കേസ് ഇല്ലാത്തത് കൊണ്ടല്ല ശരിക്കും. I deliberately left it. I thought that from the floor it may come. See, two landmark judgments that DK Basu regarding arrest and detention.
Yes.
That is covering all aspects, but still it was followed only in violation. Then came that PUCL case with 16 mandatory directions, reviewing all previous directions by various high courts. That is the present position. And came later that Manipur matter. The conversation principle is given in detail. These are the three aspects regarding this custodial violence, and all other decisions are plenty, but reviewing all the decisions came this Manipur matter and the other PUCL matter. These are the three basic decisions regarding this person. All decisions are plenty. So I have got that direction, but I thought that we are all lawyers. There's no point in reading the 10 directions. These are the 16 directions and all that. You may feel boring, that's why.
Yes.
ബാല സാഹിബിനെ ഓപ്പൺ ചെയ്യോ ഒന്ന് തങ്കച്ചൻ? ബാബാ സാഹിബ്
he himself can I think unmute.
Please unmute. Please unmute.
He can unmute. Please unmute.
Talk something. Please unmute, sir.
Sir, you please touch on the screen, then you will find it.
Unmute left side of bottom left side.
You can see the mic there.
You Please.
That is on the left side of the laptop. You can see the mic here.
KO Ashok, എന്തെങ്കിലും ഉണ്ടോ കമന്റ് ചെയ്യാം?
ഫിനിഷ് ചെയ്യാൻ തോന്നുന്നു.
അങ്ങനെയാണെങ്കിൽ നമുക്ക്
ഫിനിഷ് ചെയ്യാം തങ്കച്ചൻ, ഫിനിഷ് ചെയ്യാം.
അങ്ങനെയാണ്. CK രാമേന്ദ്രൻ, നിങ്ങള് ഒരു കൺക്ലൂഡ് ചെയ്യും.
വോട്ട് ഓഫ് താങ്ക്സ് അവരുണ്ട്, നന്ദി പ്രകാശിപ്പിക്കാറുണ്ട്. അപ്പോൾ സുഹൃത്തുക്കളെ, ഓൾ ഇന്ത്യ ലോയേഴ്സ് യൂണിയൻ കണ്ണൂർ ജില്ലാ കമ്മിറ്റി സംഘടിപ്പിച്ചിട്ടുള്ള 38ാമത്തെ ക്ലാസ് ആണെന്നാണ് എൻ്റെ ഓർമ്മ. ഈ ക്ലാസ് എന്ന് പറഞ്ഞാൽ വളരെ പ്രത്യേകതയുള്ള ഒരു ക്ലാസ് ആണ്. ഇന്റർനാഷണൽ ലോ ഉൾപ്പെടെയുള്ള മുഴുവൻ കാര്യങ്ങളെയും എടുത്ത് ഉദ്ധരിച്ചുകൊണ്ട് PV സുരേന്ദ്രനാഥ് സാർ വളരെ മനോഹരമായ ഒരു ലെക്ചറാണ് നടത്തിയിട്ടുള്ളത്. യഥാർത്ഥത്തിൽ നമ്മുടെ മനസ്സിലുണ്ടാവേണ്ടുന്ന ഐഡിയ ഇതാണ്: നമ്മുടെ പ്രക്ഷോഭത്തിന്റെ കുന്തമുന ഇതിലേക്ക് തിരിയേണ്ടത് കൂടിയാണ് എന്ന് ഓർമ്മിപ്പിച്ചുകൊണ്ട് വളരെ മനോഹരമായി, വളരെ ഇംപ്രസിംഗ് ആയി സാറ് സാധാരണ പോലെ ക്ലാസ് എടുത്തിട്ടുണ്ട്. അദ്ദേഹത്തിന് കണ്ണൂർ ജില്ലാ കമ്മിറ്റിയുടെ പേരിൽ അഗൈതമായ നന്ദി രേഖപ്പെടുത്തുന്നു. അതുപോലെ തന്നെ we would like to thank all other persons participated from various states and all other advocates, seniors, juniors, and all other advocates participated in the case. In the class, we express our deep thanks and gratitude to all advocates. Thank you.
Thank you. Thank you.
Thank you.
Thank you.
Okay, that's a we conclude. Okay, നമുക്ക് ക്ലോസ് ചെയ്യാം അല്ലേ?
Thank you. Thank you so much.
നാളെ 3 മണിക്ക് ക്ലാസ് ഉണ്ടാവും.
നാളെ 3 മണിക്ക് ഗിരീന്ദ്ര ബാബു സാറിന്റെ വക്കീലിലെ ക്ലാസ് ആണ്. മാരേജ് ലോസിന്റെ തേർഡ് പാർട്ട്. ഓക്കെ. വക്കീൽ കൂടെ ഉണ്ട്.
ഓക്കെ.
ഓക്കെ.